hot off the press with strategies, and there's going to be a lot more changes than what you are hearing and seeing so far. Again, like I said, I'm so sorry for the delay. I was in the weeds in trying to do a number of things that with all these changes that are taking place and how we're involved. And I'll tell you as we go through this, how the law firm is really involved with all these immigration changes that are taking place. But welcome for joining our Challa weekly webinars. For those who are new, thank you. I hope you will continue to subscribe to our webinars and meet with us every week. For those who have been regulars, thank you for your time and commitment to attending these webinars. We take it very seriously. And so it was supposed to be for yesterday, and it was my fault. I didn't realize it was 12 o'clock, and that's exactly the time the president was going to be sworn in, and the very historical swearing in of the very first woman as vice president, who is an African-American woman and of Indian origin. So it was, historical in many ways. And I thought there's no way that we can all be on a webinar while such an historical event is taking place. So we decided to have it today. And it was good because there's a lot of things we've learned in terms of what is down the pipeline for President Biden's initiative. And we also thought we'd address a lot of the questions that we'd seen on Telegram. So we're going to kind of do a little of both. As always, I ask you, if you've got questions, please place them in our Q&A instead of putting them in our chat. It just makes it easier to navigate. So let's get started. Ways to connect. You can connect with us either through Twitter, Instagram, YouTube, or Telegram. And please make sure you share this with your friends or any people that are currently in the immigration process. There is going to be a ton of changes, as I've been predicting all along in the upcoming weeks. And it will be, it's in your best interest to make sure not only you know what the changes are, but what are the strategies you can employ to see how they can impact you. So please join us on that. If you have missed our webinars, they're on YouTube. Please subscribe to our YouTube channel if you find them helpful, and share it with your friends. Please comment. I love to hear from you. If there's anything specific you'd like us to address in some of our seminars, please make sure to do that. So today we're going to talk about advanced parole employment authorization, because there's been a lot of chatter about that in the Telegram group. That's why it's important, even if you join our webinars, to make sure you get people to join the Telegram group, because in connecting with you on Telegram, we're able to understand what the key issues are for you, because this is for you, and address them in our weekly webinars. Travel while the adjustment's pending, portability, crafting your immigration strategy, and immigration reform with the new President Biden initiatives, and how to connect with the Challa Law Group. As you can see, I am super excited today. I was beyond just so happy to hear all those positive words out of the inauguration. I hope you all got to see that. That is democracy truly at its best. So advanced parole and employment authorization. Advanced parole is merely a permission to travel. Now, if you are in any other status besides H or L, if you travel outside the United States without the USCIS issuing you the advanced parole, you would have been deemed to abandon your entire adjustment application. Okay. That's only if you're in any other category other than H category or L. Okay. If you're in H and L, you can travel. with your H and L visa, because those are implicitly dual intent visas. You can hold two classifications together without any issue. But what had been a recent trend with the Trump administration, that if you traveled while your AP was pending and you're on an H or L, you wouldn't abandon your entire adjustment of status application, only your advanced parole. So you'd have to come back and apply for advanced parole, but you can always travel on your H-1B visa. So a lot of people have asked, so if I enter on my advanced parole, or if I enter on my H-1B visa, how does this affect my work authorization? Well, there's really a very specific issue, right? If you're on an H-1B or L, you have to maintain that status in order to obtain the benefit from it. If you're adjusting and you're on an H or L, then that means you can either be an adjustee or you can also maintain your valid H or L status. So you can travel on your non-immigrant visa while the AOS is pending. You can travel on your AP while the AOS is pending. You just have to maintain a lawful H or L status upon departure. And if you're returning in a valid visa on H or L, then you've got to resume employment with the same employer. And if you take all these conditions aside, the main thing is, if you begin using your EAD for work, this is if you're the primary H or L, because the employment, your H or L is an employment-based classification. And therefore, if you work for somebody other than your H and L employer on the EAD, you're no longer in valid H-1B status. You can work for your employer on your EAD with H and L, but it's only if you decide to work for somebody other than. That means, what does that mean? That means you're still an adjustee. You're just no longer in H or L status. So that's the issue. So employment authorization documents, you can work with any employer. As I said, if you're using your EAD to work for another employer, you're no longer in valid or H or L status, so there's no safety net. Now, what happens, a lot of people ask, well, I know I can't work for anyone. Can my spouse arrive in the US on an H-4 visa and then work on her EAD? Yes. Can the spouse work on the H-4 EAD or the adjustment of status EAD? It doesn't matter, because the spouse's status is dependent on the primary H or L visa holder status. Therefore, how they work or what they utilize for employment authorization does not matter. They have no restrictions. So the other question is, well, okay, my spouse doesn't have restrictions, but I'm a primary H or L. Can I change employers leveraging AC-21? Well, that depends. Well, first, what we'd like to say is the reason why we always think it's good to maintain your H or L while you're in adjustment of status process is because if something should happen to the adjustment through no error of your own, maybe it's through a mistake that the USCIS has done. That can happen. You won't be stressed out. You'll have your H or L status while that error gets addressed. So I've seen it enough times to use it as a cautionary tale for everybody who is going through that process. So what about some changes in employment and portability issues? Well, people have asked, I've changed employers after my I-140 was filed, but now my priority date for my previous employer is current. Can I file an I-485 with my old employer? Well, permanent residencies for prospective employment, which means future employment. If there's going to be an I-140 that's filed for your old employer, either through a downgrade or for some other reason, any I-140 that's filed, you will need to demonstrate ability to pay from the time the labor certification was filed. So a lot of times you're able to demonstrate that through showing your wages, your ability to pay, that the employer has been paying your wages. Well, if it's your previous employer, you don't have those, he hasn't been paying you the wages. So his net income has got to be high enough from the date of the labor certification every year thereafter, till you file now, has to be greater than your proffered wage in order for the previous employer to be able to demonstrate ability to pay. Now, if an I-140 doesn't need to be filed, you can go ahead and file the 485. There may be some questions that are raised. We have to see how this administration will handle that. Typically, they just want to know that you do intend to work for this employer. So you will have to file an I-485J, but ability to pay in the past has not been that big of an issue at the I-485 stage. But the Trump administration has made it an issue. So the question is going to be, is the Biden administration going to change that policy, and how quickly are they change that policy? The employer has the intention of employing the individual once they receive the green card. Even if the employer withdrew the I-140, as long as the I-140 was filed within the 180 days of the perm certification, the ex-employer can refile the I-140. Remember, you've got to think about ability to pay, so that's an issue. And both the employer and the employee both have the present intent for the employment agreement. So the employer is saying, yes, I have a job offer. He's affirming that on the I-140J under penalty of perjury, okay? And the employee is affirming that they are going to work for that employer after the green card is approved under penalty of perjury. So it's the present intent. That is the intent at the time of filing. So you can later change your mind, and that's why we've got the portability of the permanent resident status. But, they may ask for evidence to show how are you able to demonstrate that you did have the present intent. So if you all had been regulars in my webinar, I have been saying for months, make sure you keep and maintain any communication you have with your employer, even if it's emails that say, hey, I'll join you once my green card is approved. So when can you change jobs? Well, you can leverage AC-21, but 3 conditions have to be met. I have been listening to, the forums, and the 3 conditions that have to be met are the I-140 must be approved. If you downgraded, the new I-140 has to be approved. So the new I-140 has to be approved. The I-485 has to be pending for 180 days, and it has to be same or similar employment. Okay, so 3 conditions. I-140's got to be approved. I-485 has to be pending for 180 days, pursuant to the receipt notice on the I-485, okay? And you have to be working or same or similar employment. The good news is you can even be self-employed if the conditions are met. So you can work for yourself. But all three conditions have to be met. We keep getting questions on Telegram saying, my I-45 has been pending for 180 days. Can I port? And that doesn't tell me everything. It doesn't tell me whether the other two conditions have been met, whether you have the I-140 approved or not, which is needs to be critical, and whether you'll be working in same or similar employment. Same or similar employment. There are two standards that we're not sure which one is going to play, but the pre-Trump, hopefully the post-Biden, USC defined same or similar very broadly. They would compare the job duties, outlining the perm, and as long as you interlaced, that means showed some commonality with your new job duties, there would be no problem. It would be deemed portable pursuant to the USCIS, even if the SOC code was different, even if the wages were not the same, it would still be deemed. So they would specifically look at the job duties in the perm and the job duties in the I-140. Recently, the Trump administration has narrowed the definition of same or similar. They said they will look at the SOC system. They'll check the job duties of both positions, skills, education, training, certification, that the SOC code from that the wages associated with each position, and any relevant, credible information. And they would consider the totality of the circumstances based on the preponderance of evidence. Basically, what they're trying to say is we're going to try to find a way to say it's not same or similar. That is the bottom line. And they tried to concoct all these things to address that. I'm pretty sure that the Biden administration will go back to a more broad interpretation. And the reason why they took a broad interpretation for same or similar is because they understand these backlogs took 10, 12, sometimes 14 years. And it would be ridiculous to think that there wouldn't be any career progression, that there wouldn't be any changes in the market. So what was relevant as a job 10 years ago may not be that relevant now. So that's why they had always wanted it to be broader. I'll keep you posted on whether they're going to address this, but we'll have to see. What if you get a promotion? Well, as long as it's a career progression, that's never a problem. But, the biggest thing is, promotions have never been, because there's usually a linear process, and you can show how you've, grown. So, you may have supervisory duties now. There may be other duties now that were not present at the time you filed the labor cert. So again, it just depends on which standard they're going to utilize. The pre-Trump standard, post-Biden standard, hopefully, or the standard outlined by President Trump. Now, some other questions that we have seen is whether people can file multiple I-140s. Yeah, if you just started the perm process, you can actually leverage a perm for both the EB2 and EB3 if it's crafted correctly. And in fact, you can file them because you're filing both of them at one time. So one of them will have the labor certification. You can file them premium processing. So that's really something to think about if you haven't filed your I-140 pursuant to a perm process that you're currently embarking on. Preserving a perm. As long as a perm was filed within 180 days of its certification, it can be utilized for a number of things. If it was filed and, for example, there's a restructuring, and so because it's a successor in interest, you have to file a new perm. If the employer previously withdrew it or revoked your previous I-140, and now they want to resurrect it because you plan to return to your ex-employer, they can refile the I-140 as long as the original one was filed within 180 days. So as long as the perm was filed within 180 days, for the most part, it stays valid for any utility thereafter. The only issue is, remember, if there was any fraud or misrepresentation, then it becomes problematic. So the perm vests with the priority date vests with the beneficiary once the I-140 is approved. You can use that priority date for subsequent filings, even if it's in a different category. Even if your employer subsequently revokes your I-140, it does not impact your ability to use that priority date. The only time that your priority date will be taken away from you is if the agency finds that there was misrepresentation in the perm, or that the original perm had deficiencies and it was incorrectly approved. And of course, if the perm is denied, no priority dates will be established as a result of a denied petition. Now, some people have had priority dates and their spouses have had priority dates. So they've said, can we use our spouse's priority date? No, you can't. Priority date vests with the individual. So you can't leverage your spouse's priority date. But what you can do is, if your spouse was born in a different country that is not subject to backlogs, you can utilize their country birth for purposes of cross-chargeability when you file your adjustment of status. So for example, if you're from China or India and your spouse may have been born in the UK, and then their family migrated back to India, you both fell in love, got married, et cetera, and now you're filing your perm, and of course you're born in India, so you're subject to the backlogs. But because your wife was born in the UK, there's something called cross-chargeability, where you're able to utilize her country of birth so that you're not subject to any backlogs. So if there's any bachelors or bachelorettes out there, and you're currently kind of maybe looking at options for marriage and beyond, this shouldn't be an issue that you think about in your calculation. Believe me, there's a lot more important issues than cross-chargeability. But if you like the guy, he's great. Remember, you can use cross-chargeability. So always remember, there is the ability to do priority date interfilings, especially with the visa bulletin fluctuations. So if you've got an approved I-140 in a different category, or you listen to this particular webinar and you know that you can actually file with one perm, you can file two I-140s. If you do that, let's say you filed under EB3 because you wanted to be able to file the adjustment of status. Then EB3 kind of retrogresses and EB2 is advancing. Well, if you have an approved EB2, you can interfile. You can also do things like, if you don't have the approved EB2, you can also do things like amend your EB3 back to EB2, but it takes some time. But this is something to think about. And of course, you have to make sure that you've maintained eligibility for the application. So let's talk about some changes. So one of the first things on January 20th, President Biden did was revoke the President Trump's proclamation banning visa processing for certain types of applicants. So there's no ban anymore. So the application, the proclamation directs the Department of State Secretary to direct the embassies and consulate, consistent with the current applicable law and visa processing procedures, including anything related to COVID, to resume normal processing. You don't have to worry about an emergency appointment anymore. You don't have to worry about national interest waiver anymore. You are able to move forward. It's still going to be subject to any restrictions based on COVID, but the proclamation that was in place is no longer valid. Boom. I told you that that would happen immediately. Secondly, immediately, their White House Chief of Staff, Ron Klain, issued a memorandum saying that certain regulatory actions, in part, would be withdrawn. So all rules pending in the Federal Register that have not been published are going to be withdrawn. Agencies must consider postponing effective dates for regulations that have been published but have not yet taken effect. And as a result, like the modified version of strengthening the H-1B visa classification final rule that was sent on January 15th will be withdrawn. In addition, any final rule that has been published but not yet taken effect may, upon further agency action, be postponed. And I'm pretty sure that the wage selection process is going to be one of them. So good things all in one day. The President Biden also outlined a very skeletal idea of what actions he planned to take place. Aside from legalization, DACA, the border issues, things like that. On the business immigration front, the team that's heading this is Senator Bob Mendez and Representative Linda Sanchez. And they're going to be working with a team of 6 women lawmakers calling themselves the Closers. Zoe Lofgren, and you all must know Zoe Lofgren from, she was the one that was spearheading all the positive immigration bills that eliminated the backlog that was much abuzz on the Telegram group. And I think somebody even said to me, well, you don't want the backlogs to be eliminated, which is the most ridiculous thing in the world. Because assuming that I was only concerned for money, I'd have more people adjusting. I would make more money. But B, knowing that I've got family members in that process, let's hope that my concern for the greater community would override, any temporary benefit. But recently, Amit Shah, who's counsel at the House Judiciary Committee, who was an intern with our firm, and I know her very well, is now attorney she was the House Judiciary Committee. Now she's working directly for Zoe Lofgren. So we have a inside track to kind of getting these done. And the slide that I was working on that I could not put up, I've been selected to be part of the API 100, Asian Pacific Islanders, 100 group of individuals. This is only through invitation by, the board, but to participate in policy making. So we had a call maybe about 2 weeks ago, 2 Fridays ago, with President Biden's director of interagency, initiatives. And this person was really into it. So we were privately talking on the chat as the meeting was going on, and she gave me her email. And I told her I had some ideas as to how to make, if President Biden is going to do some reform, how to make it more easier, more efficient. So I will be talking to her as well and the Biden administration about what we can do to make the process easier for you. So one of the things that the Biden administration talked about was advanced STEM degrees, giving them some way to stay in the U.S. upon graduation and eliminating hurdles for employment-based green cards, maybe even exempting advanced STEM graduates from any green card caps, and eventually giving a green card to people who complete their PhD, which would be great because we need more STEM grads in the United States. In the idea of keeping family together, the bill wants to reform the family-based immigration system by clearing the backlogs, recapturing unused visas, eliminating lengthy times, and increasing per capita visa caps. They also want to eliminate the 3-year, 10-year bar, which would be very good for a lot of people that are in a bind right now. And they want to allow immigrants with approved family sponsor petitions to join family in the United States temporarily while they wait for the green cards to be available. That is so great, because otherwise spouses of green card holders, have to wait, for such a long time. And even, spouses of US citizens, where there is no backlog, the processing time takes about 1.5 years. So that's never good for a family. So I'm super thrilled that they're going to do that. I know all of you have been asking about, well, what about us, H-1B visa holders? And we've got children who are aging out. The initiative on the Grow Our Economy not only addresses, as we talked about before, the visa backlogs, but they want to provide dependents of H-1B visa holders with work authorization and prevent the children from aging out. They also want to give a pilot program to stimulate regional economic development and giving DHS the authority to adjust status based on macroeconomic conditions and incentivizing wages for the non-immigrant, highly skilled to prevent unfair competition with American workers. So, that's amazing, because that gives local authority greater ways in which they can meet the local needs, meet the needs of their locality, whether it be, issues relating to healthcare or, special skills with, in cybersecurity, because they're sure, whatever it may be. So I think it's going to be, we have to see. And like I said, I'll be in touch with the folks that are putting this together. So that's why it's important that you connect with us, on Telegram, as well as these weekly webinars. Our next webinar will be next Wednesday. And as I'm going through this, I'm reaching out to a couple of folks today. So by time, hopefully we'll get a response by the webinar for next Wednesday. And then we can actually start crafting some strategies, because there's still a lot of ambiguity. There's still a lot of overlay between what was Trump and what will be Biden. And the problem is, it was like an avalanche of new changes, new regulations. They took out the adjudicator's field manual, which is what adjudicators used to use to review cases. They replaced it with the USCIS policy manual. And by doing that, made a lot of significant changes. So they knew that if this, I think that from the election, they actually started just inundating the changes in hopes that the new administration would take a long time to catch up. But luckily, we've been keeping track. So that's something that I'm going to let the administration know, so that we can get that addressed, especially some of the minor policy issues, like the increased discretion for adjustment applications, and which is something that would impact all of you. Remember that Trump, before, if you were eligible based on, whatever your classification was, then, as long as you didn't commit a felony or 2 misdemeanors, there wasn't much really that they would review. Now they have these long list of things that they're using to outline whether, so it's 50% eligibility, 50% discretion by the adjudicator. So those are the types of things I want to bring to the Biden administration's attention, so that it's not, the adjustments that you all have pending are not going to be mishandled. So I want to, again, there's going to be a lot of buzz going on in the next several months. So make sure that you share our contact. I'm asking you to share it with at least 5 of your friends. 5 new friends. Get me 5 new friends on our Telegram group, and have them subscribe to our webinars. And let's make sure that we, have these opportunities. And it's not just me talking to you. I actually read through all the things that you all are discussing. So I know how it impacts the people that are going through it. So the more people we have, the greater our voice will be. So help me help you. Invite 5 people. Let's make this formidable. So when I go to talk to Zoe Lofgren or the Biden administration, I can say, we've got a group that's this big, and this is what I'm hearing. This is what are people going through. It's a lot more persuasive than I say, a couple of my clients said this to me. So help me help you. Let's grow this base so we can really start making impactful changes on immigration reform for you, for him. So please do that. 5 people. And keep connecting with us, and to get the latest YouTube videos, check out some of the videos that are already online. This one that they'll be posting up fairly quickly, and I'm pretty sure in chat my team has already put up all the links. If you haven't, there's a lot of questions today. So if we don't get a chance to answer all the questions, then please email us at info@challalaw.com. Sometimes the questions that you all ask, it's not enough information for me to give you a real meaningful answer. And I ask people to email at info@challalaw.com, not because I don't want you to email me directly. You can, lchalla@challalaw.com. But when you email at info@challalaw.com, it actually goes to 4 people. 4 people. So we can make sure that, and we get a lot. I mean, we get a lot of questions on a daily basis. And so we can make sure that your questions get answered. So please email us at info@challalaw.com. And now we're ready for our question and answer session. And I will invite Shaker Challa to go ahead and take over the moderating. Sorry for the, and for all the people that are participating, I'm so sorry for the problems with the connections today. I usually don't have a second monitor up, and I think that caused a lot of the issues. But it's a great day, new dawn, new beginning, hopefully a great 2021 for all of you.
All right. Thank you, Lakshmi. Good afternoon, everybody. We need to have a hard stop in about 5 minutes after 1 o'clock.
Perfect.
So try to address as many questions as we can, but we couldn't. If we can't, then we'll have to just request you guys to send an email again. We have another engagement. So let's start with the first one. Prem Pathak, can I maintain primary H1 and use EAD to work or to do business?
What's the first sentence?
Can I maintain primary H1 and use EAD?
Not if you're going to use that EAD to work for somebody other than your H-1B employer. So keep this YouTube video with, you all need to look at it again, because I have answered this. You may be new, but I have answered this question again and again. It's simple. If you use your EAD for working for someone other than your H-1B employer, you are no longer in H-1B status. Bottom line.
All right. Gurmukh Singh says, I was asking, good morning, Lakshmi, hope you're well. I'm currently on L1 visa, and I and my spouse have filed a I-485 AOS with AP and EAD application filed on October 16, 2020, and fingerprinting was done. Can I and my spouse travel pending approval of AP while continuing with current employer and return back with the same employer on L1? Please advise.
Okay. So what happens is your adjustment will be fine. So you can travel, and this may change, because previously you could travel while your AP was pending and they would still process it. So you could travel H's and L's, only H's and L's. But recently that changed. So again, we're at that that crossroads where, you know, the Trump stuff kind of overlaps until the Biden people can get a handle on all the changes that are made. So if I were you, I'd be incredible. If you're okay with refiling the advance parole when you get back and applying for a new one in case the Biden administration is not able to revert back to the old policy by the time it's adjudicated, then it's okay. But as long as you have a valid L, you've been maintaining valid L status, you can travel on the L visa and come back to the United States. If the Biden administration is able to address this change in policy that's taken place during the Trump administration, your AP will be processed without interruption. If they do not get to that as of yet, because there's so many big issues to get to, then all you have to do is refile the AP. So the risk is very minimal.
All right. Prem Pathak is asking for self-employment, how to file 485.
Prem, you must mean 485J.
J, yeah, sorry. It just says J, I couldn't.
Okay.
It's that J at the end.
Again, I'm going to say this. I-140's got to be pending. I mean, I-140's got to be approved. Three things, 3. When you think of portability, think of the number 3. All 3 of those conditions have got to be met. The I-140 must be approved. The I-485 has to be pending for 180 days pursuant to the receipt notice of the I-485. And 3, it's got to be in same and similar employment. So if those 3 things have been met, you just file an I-485J and you would sign, you know, as a self-employed individual. Another issue, you didn't ask about this, but I'm going to tell you. If you're on an H-1B, and unless you transfer your H-1B, you know, if you've created a company, you can transfer your H-1B to the company you've created, as long as you have a board for that consulting company and work vis-a-vis through the company. And that way you don't lose your H-1B. But if you decide not to do that and just start a business on an EAD and not worry about your H-1B, then you can do that as well, as long as the 3 conditions of portability have been met.
Okay. Question from an anonymous attendee. Will the Democrats help the backlogged community this time? During the Obama years, we were cheated out of I-140 EAD. How do we know this time will be different when Democrats are always only talking about illegal immigrants?
Well, I have to tell you that first, you're wrong. The Senate passed a bill to overhaul immigration in a bipartisan effort. Boehner, who was Speaker of the House at that time, would not allow the bill to even. What happens is whoever is head, so you all understand how the U.S. Legislative system works. Whoever is the party that is head of either, you know, you've got the House and then you've got the Senate. They have mechanisms in which they can control what bills they will allow to be voted. It's got to be voted by both the House, it's got to be approved both by the House and the Senate, and then it goes to the president, right? House, Senate, it goes to the president. Now, the problem has been that there is bipartisan support. So, but because over the past few years, because of the, you know, I guess the power struggle, if the Democrats control the House, they didn't control the Senate. They controlled the Senate, they didn't control the House. Now we are at a place where because you only need a simple majority to get a bill passed. The Democrats have the House and the Senate. And all the bills that have, even the Biden, as you can see today, earlier I talked about how they are looking to remove the backlogs. And, recently it was, and Zoe Lofgren said this, that at the Senate, it was folks like, I think it's Rand Paul and a couple of other representatives tacked on some like very not very helpful immigration provisions to increasing the backlog. And they said, no, they would never be able to do that because it wouldn't work. So they will. So I think you will see that. And now, like I said, I was worried about the Georgia race. I was worried about the Georgia race solely for the fact that if the Democrats didn't get the House, McConnell can just stop bills from being presented on the floor. He controls the agenda. So now, because the Democrats have both the House, the Senate, and the White House, you will see that some very positive changes will take place. Have faith.
Okay. Sanjay Pathak, is there any information on child who came with their parents on H4, studied from grade 5th and now aged 21 plus, and by any way to be part of parent I-485?
Right. So he's already aged out. I know there's some protections that are in place. One of the things I'm going to recommend is that they try to look at this issue, especially for those people who've recently aged out and they're here either on an F1 status, or some people have had to send their children overseas, which I think is just so, it's so horrible. See if there's a way in which we can grandfather some of these individuals to benefit from the current immigration process. So I am trying. I will be advocating for that very loudly, I assure you.
All right. Sandeep Kaur is asking, currently it seems like DHS is not processing any 221G. I know in the past some people got 221G and got approval within 4 to 6 weeks, but during COVID-19, I haven't heard from anyone who got clearance on 221G.
Right. So now,
will there be any improvement or regular process clearing on 221G?
Yeah, I think they are supposed to resume what the proclamation did was the president directed the Secretary of the Department of State to make sure his visa and the embassies are resuming normal processing, notwithstanding any restrictions based on COVID. So although, the Trump administration, really, they haven't been doing anything since November. I think you'll slowly see, there's going to be quite a bit of backlogs, but I think you'll slowly see all of that moving forward.
All right. Cheetal Shah, can we travel on AP and not use EAD to still call ourselves on H-1B status while I-485 is pending?
Yes. As long as you don't work on an EAD for any other employer except for your H-1B employer, you still maintain your H-1B status.
All right, Anil Vishwanatha. I'm looking for family-based green card as my brother is here and I am his first cousin, as we are using same family name. Would that work?
No, you're not legally his brother, even if you're using the same family name. You have to be a blood relation. Your parents have to be the same for you to be considered a brother or sister. The other thing is that queue is 12 years long. So you probably want to think of another mechanism to get permanent residence in the US.
All right, next one is Venkat Challa, same last name. Hello, Mr. Challa. He wants to know, please share the link for Telegram group. It's already shared on the chat. So please look at the chat and you'll see all the links for all the social media platforms that we are on, that you can follow us and keep yourself up to date on all the regulations. Thank you. Okay.
Thank you. I was going to say thank you, Venkat. And if you could just share that with your friends. And, that's all I'm asking is everybody share with 5 people, because if you want me to get changes done that help you, like protections for your children that have aged out, we've got to grow the group. So let me help you by sharing with 5 people.
Okay, I got 2 more questions, and so please, I request you all, like I said, we have a hard stop, already past that, but we have to go for another meeting. So please send your questions to info@challalaw.com. So I got 2 more questions that I'll take that are already here. So let's look at anonymous attendee. Thanks for the information. I've applied for STEM extension and I have not received the I-797 receipt yet. My OPT has expired on the 15th of Jan and I'm looking to change my employer. The HRs are asking for the I-797 notice. What action can I take to maintain status and change employer?
I know, and you're going through what there's a lot of students that are going through this at this time, and I think I may have even mentioned that last week. Not a lot. Let's see how we can make some noise about this and get this. My list right now is almost about 3 pages of what I'm trying to get the administration to address immediately. So this is one of the things that has been on my radar that I learned about. And so let's see what happens.
All right, last question before that. Thank you from Sandeep Kaur. Thank you, Lakshmi. Rahul V, yours the last question. Anybody else? We didn't answer, we apologize. Please do send an email to info@challalaw.com. Rahul is asking, what's the renewal fee for C9EAD?
It's the 767, it's whatever the 765. It doesn't matter what classification you're asking for work authorization. The work authorization fee will be the work authorization fee. And then I believe the biometrics fee, but Kara should be able to answer that question up on chat. There she goes. And if you didn't get your questions answered, please email us, or let's try a discussion on Telegram if you think that's an easier way to get connected. I look forward to talking to you again next week, and Chandrasekhar will make sure I have no technical difficulties with my process next week. But yesterday was a great day. 2021 is going to be fantastic, and I'm going to be working very hard to make sure that the laws and regulations are changed to help you. So thank you for joining. Thank you, Shekhar.
Thank you, Lakshmi. Thank you, everybody all. Have a good day, good week.